Washington, Reuters. The U.S. Supreme Court on Monday was set to hear a high-stakes case that could deprive unions representing police, firefighters, and certain other public employees of a key source of funds, millions of dollars in fees they can collect annually from non-members. Dueling groups of protesters gathered outside the white marble courthouse ahead of the scheduled one-hour argument. The 9 justices will weigh a challenge backed by anti-union groups to the legality of fees that workers who are not members of public sector unions must pay to help cover the costs of collective bargaining with state and local governments. Union-backed protesters held signs saying €1 or America needs union jobs €1, while those supporting the challengers had signs saying €1 stand with Mark €1, a reference to the plaintiff in the case, Illinois state worker Mark Janus. 24 states require payment of these so-called agency fees, covering roughly 5 million public sector workers. A Supreme Court ruling disallowing these fees would deal a setback to American organized labor at a time when the movement already is in a reduced state compared to the past. Depriving unions of agency fees could undermine their ability to spend in political races. They typically back Democratic candidates over Republicans. The justices considered a similar case in 2016, and after hearing arguments appeared poised to overturn a 1977 Supreme Court precedent that let unions force non-members covered by contracts negotiated by organized labor to pay fees in lieu of union dues to help cover non-political union expenditures. But the death of conservative Justice Antonin Scalia the following month left the court with an even split of conservatives and liberals, and its 4-4 ruling in March 2016 failed to settle the legal question. Republican President Donald Trump trademark's appointment of Justice Neil Gorsuch last year restored the Supreme Court trademark's 5-4 conservative majority. Gorsuch could cast the deciding vote in dooming agency fees. The 2016 case was brought by non-union California public school teachers. Janus, the plaintiff in the current case, is a child support specialist for the state of Illinois who opted not to join the union that represents employees like him, the American Federation of State, County, and Municipal Employees, AFSCME. In both cases, the challengers argued that being forced to pay the agency fees to unions whose views they may not share violates their rights to free speech and free association under the U.S. Constitution trademark's First Amendment. Unions in both cases contended that mandatory agency fees are needed in order to eliminate the problem of what they call €1 or free riders non-members who benefit from union representation, for example through salary and working conditions obtained in collective bargaining without actually paying for it. More than 100 people loudly demonstrated outside the courthouse. Dexter Guptill, a computer support technician for the American Federation of Teachers, said that if the justices rule against the unions, EMI co-workers would wind up being forced to spend their effort representing essentially free riders €. 24 states have agency fee requirements. While 28 states have so-called right-to-work laws that prohibit mandatory agency fees, Wisconsin and Michigan have exceptions for police officers and firefighters that permit agency fees covering those workers. In those right-to-work states, unions still represent workers but membership rates are lower. Federal employee unions cannot collect agency fees.